Thanks, Stephen. So I know I said this last time, but in 2004 I was a student of the Innocence project here at Griffith and clearly remember reading Bob's work at that time and his website as well. The contributions that he has made in his career to cases of wrongful conviction, wider awareness of wrongful conviction throughout the country, and law reforms, including second and subsequent appeals, is really second to none. Bob was tasked with the topic of addressing the issue of deciding what kinds of cases should be referred back to the court. Thank you, Bob.
Thank you very much, and I'm very pleased to be here today. I acknowledge the Aboriginal owners of this land and wish to mention that I shall be dealing in the course of my paper with the case of Mr. Derek Bromley. He's an Aboriginal man from South Australia. He's been imprisoned for just over 40 years. He still claims that he was wrongly convicted. The High Court recently rejected his application for leave to appeal, and we feel that that was an improper decision. I have suggested that he engages a further procedure which would allege that his conviction was obtained by fraud. That would establish an interesting and new procedure for dealing with wrongful conviction cases. It's not something that I can deal with now in this paper, but I would just like to mention to you that I do have considerable resources on that issue on my website. I also have pages dealing with each of the criminal cases review commissions in Australia and other countries. This paper that I'm giving today will be on my website on Monday, and it will have links to various resources there for you. The website is called Networked Knowledge, so that's network with an ED on the end, Networked Knowledge. If you Google that, you'll find your way there with no trouble. So first of all, in considering the threshold test for a referral of a conviction by a body, such as the CCRC in Australia, to the Court of Criminal Appeal, there are a number of contextual factors that need to be considered. Historically, judges have not been favourably disposed to support proposals for post-conviction reviews. The Australian appeal rights were adopted from the British appeal rights established in 1907 and taken up by the Australian courts soon after. For over 100 years, the judges maintained the view that the legislation provided a right to only one appeal. They said the appeal court could not go beyond what the legislation provided. Yet, when we examined the appeal provisions, they actually said nothing about limiting the right of appeal to only one appeal. They simply stated that a person may appeal under specified circumstances. However, the judges were not entirely hard-hearted about a possible further appeal in special circumstances. They explained that in a deserving case, a legislative provision allowed for a person to obtain a referral to the appeal court via the Attorney General. However, when Mr. von Einem complained about his application being knocked back, the judges said that this procedure was beyond the reach of legal rights. They said the Attorney General could refuse an application for any reason or for no reason at all. The Attorney General was not even required to read the petition. We thought it strange that a piece of legislation setting out a procedure as a safety net for a person claiming to be wrongly convicted did not impose any obligations upon the person who was given the power to make a referral and did not grant any rights to the citizen to whom it applied. We subsequently found references in the law reports to statements by Australian and British judges who had clearly proclaimed that there was no such thing as an unfettered discretion. So in November 2010, we compared the responses to wrongful convictions by Australia, Britain and Canada in our book Forensic Investigations. We had recommended a CCRC be established in Australia. An independent member of the Legislative Assembly in South Australia, Anne Bressington, agreed to introduce a bill to that effect to the South Australian Parliament. It was based upon a similar provision which, as we've heard this morning, had been operating in the UK since 1997, and which by then had led to the overturning of several hundred convictions. It provided that where a person had been convicted of an indictable offence, the Commission can refer the conviction back to the appeal court, and in doing so they must provide the appeal court with a report of their findings and the reasons for making the referral. They do not appear, of course, to make oral submissions on the appeal. The conditions for making the referral are that the Commission accepts that the existing appeal rights had been exhausted, there is an argument, evidence or information not raised in the earlier proceedings, and there's a real possibility the conviction would be overturned upon the referral. So what were the prospects for us in establishing a CCRC in South Australia? Well, there were absolutely none. We saw it as an opportunity to garner interest and grow support for the issue by presenting the legislation to the Parliament. So we thought it would help support the issue and publicise the issue, much as this symposium is doing today. It led to a good deal of media interest and expressions of support, and they're all on our website. So then we looked to the human rights issue. We formed the view that when a person had been convicted on false or misleading evidence or procedures, such errors had not been corrected by the time of their appeal, and the convicted person was then unable to invoke any further legal procedure, as that was the position at the time. They had obviously been denied the right to a fair trial and the right to an effective appeal, rights which were due to them under the International Covenant on Civil and Political Rights, to which Australia is and was a signatory. Excuse me. We put our view to the Australian Human Rights Commission, and they issued a report in November 2011 confirming their support for the views that we had expressed. So the report from the Human Rights Commission had stated that the criminal appeal system throughout Australia failed to comply with international human rights obligations. They covered the procedural aspects of the right to a fair trial, the right to an adequate process to challenge a conviction, and the right to written reasons for dismissing an appeal. As they said in their report, the current system of criminal appeals in Australia for a person who's been wrongfully convicted or who had been subject to a gross miscarriage of justice to challenge their conviction may not be fully compatible with the right to a fair trial as set out in the ICCPR Article 14.5. In the absence of a national body, the establishment of a South Australian Criminal Review Commission is one mechanism by which South Australia could ensure compliance with international human rights standards. It should be noted that the Law Society of South Australia, the Law Council of Australia, the Australian Lawyers Alliance and Michael Kirby all supported the idea of a CCRC, with some stating that it should be done on a national basis. After considering the Human Rights Commission report, the Legislative Review Committee of the Parliament made three important recommendations. The first was that it should be established a forensic review panel which could refer cases back to the courts for a review. This was similar to having a Criminal Cases Review Commission, but focusing on forensic issues. There should also be an inquiry into the use of forensic evidence in criminal proceedings, because in our submissions, our detailed submissions, we had established substantial difficulties with the forensic evidence in a wide range of cases. And they also said there should be a new statutory right of appeal. The government decided to implement only the recommendation for a new right of appeal, and one MP said that this was unfortunate because the recommendations had been unanimously supported by the committee, which had a majority of government members. So the right to a second or further appeal. The Parliament had acknowledged that the recent amendments had been made to double jeopardy provisions. What this meant was that prosecutors could now bring another prosecution where fresh and compelling evidence had been discovered of possible guilt of an offence for which a person had been acquitted. So they reasoned that if the prosecutors could have a second go, why shouldn't those claiming to be wrongly convicted also have a second go? So, without further ado, they transposed the wording of the double jeopardy provisions into the provisions to establish the right to a second or further appeal. A great difficulty arose because of that. This meant that on an application for leave to appeal, it would have to be fresh and compelling evidence which should, in the interests of justice, be considered on an appeal. The new appeal bill replaced the CCRC bill which we had put forward. With government support, it was passed without dissent and came to effect in May 2013. From the outset, it was made clear by the politicians that a higher threshold was needed to deter vexatious prisoners clogging up the courts with hopeless applications. In one case, prior to a parliamentary meeting, the politicians were saying, yes, all the prisoners are going to be sitting around drafting applications to the appeal courts. And I thought, you really should get out of your office more often and go and talk to some of them and find out what they really do. The bar for a second or further appeal, it was said, needed to be significantly higher. Yet the rationale for this is unclear. If the convicted person was not responsible for the Crown's non-disclosures or false or misleading evidence at their trial, why should they be at any disadvantage after the error is discovered? A higher threshold for a further appeal is also inconsistent with the provisions of the ICCPR, which states clearly that at each level of appeal, all persons should be treated equally. However, in the appeal of Mr. Bromley, the higher threshold was taken to new and unprecedented levels, which, if not resolved, will have fundamental implications for any role for a potential CCRC. As we pointed out in our submissions to the ACT, when they were thinking of introducing the new right of appeal, in an appeal by Mr. Van Beelen, 2 appeal judges said the piece of evidence was not compelling. During the course of the appeal application, 6 High Court judges and the Chief Justice of South Australia on the earlier appeal said it was compelling. And as we went on to explain in relation to Kerrick Bromley, the situation then became much worse. So we had a real conflict between the judges trying to determine what the word compelling actually meant. And the horse and hardly got out of the stable by then. On the application for leave to appeal in the case of Mr. Bromley, the Court of Criminal Appeal said the evidence of the expert witnesses in the case who had appeared before them was not compelling. The forensic pathologists for the defence and prosecution were agreed that the evidence of prosecution witness at trial as to the cause and manner of death was not based upon acceptable scientific principles. 2 of them, one for the prosecution, one for the defence, had given very similar evidence at the appeal in Mr. Keogh's successful appeal, which had occurred previously, after he had been imprisoned for just over 20 years for a crime which eventually the appeal court established had not occurred. On that occasion, their evidence was accepted by the court, so that's on the occasion of Mr. Keogh's appeal. The evidence of the forensic pathologists was accepted by the court to allow for the overturning of the conviction. And in Mr. Bromley's appeal, their similar evidence was discounted, the judges said, because the experts had not examined other, unspecified evidence which may have influenced their judgments. A similar approach was taken to the 5 experts in the Bromley appeal, psychological and psychiatric experts, who had given evidence about the mental capacities of the eyewitness in the case. The prosecution expert and defence experts were all agreed as their findings which were adverse to the prosecution case at trial. The appeal judges again determined that the experts had not examined other, unspecified evidence which may have affected their judgments, and their evidence on the appeal was to be discounted, was the word they used, and I thought, well, maybe by 5% or 10%, but it appears by 100%. And so the expert evidence was rejected in its entirety by 8 highly qualified experts. So the evidence of all 8 highly qualified and experienced experts was dismissed at a preliminary appeal because they'd failed to consider other material the appeal court thought to be relevant. Now look, it's well accepted that potential expert witnesses at trial are given written instructions about what is being asked of them, and they're given copies of evidence, materials, specimens and reports which they are required to evaluate. At the extensive pre-appeal and appeal hearings in Mr. Bromley's case, they had not been asked why he had not reviewed additional materials which the appeal court later thought to be so important, and which had not been made available to the experts earlier. The experts had not been asked about whether those materials would have affected their judgments, or whether they had the skills to make such assessments. Clearly, these are the sorts of issues which would be relevant to the task of any CCRC assessors or commissioners who'd have to decide about the potential for further successful appeals, and for legislators who have to determine what they are to set as their criteria for a CCRC. Within a short space of time, the new appeal rights were adopted by Tasmania, Victoria, Western Australia, Queensland and the ACT, and by implication in the federal jurisdiction which picks up state procedural provisions. The previous appeal rights had been in common form for over 100 years. Now, each state and territory began to add refinements to their provisions as they introduced them. On one occasion, a draft bill stated that a refusal of leave to appeal should not be the subject of any appeal, and an application could be rejected without hearing any written or oral argument. Thankfully, they were removed at an early stage, but they served to indicate the level of antagonism that can exist within the system to the development of any further appeal rights. The new appeal rights had not been subject to any meaningful discussion or debate before being implemented in South Australia. They were restricted to fresh evidence cases, ignoring the issues of fresh argument or procedural error, which are criteria for the UK CCRC. The new appeal right requires compelling evidence to be adduced on an application for leave to appeal. Previously, for criminal appeals in Victoria, Queensland and New South Wales, it was said that the courts disregard the requirement for leave and simply proceed to hear the appeal. So the appeal issue on a first appeal in those states at least is not a significant issue. But on substantive appeals, the raising of a reasonable doubt might have been sufficient for a successful appeal. Now, it might appear that similar issues would not be sufficient for the grant even of leave to appeal. We did provide submissions to each Attorney General setting out our concerns for each jurisdiction which moved to adopt the new appeal provisions, and our submissions are on the relevant pages on our website for each of those jurisdictions. It's important to note, as was mentioned by the discussion on the CCRC in the UK, the UK CCRC was set up in the aftermath of the overturning of the convictions in what became known as the IRA bombing case, Birmingham 6, the Guildford 4, the Macquarie 7, and case of Judith Ward. The consternation was so great, the government felt compelled to act. However, previously things were not so. Lord Denning, the former head of the Court of Appeal, had once remarked that if those convicted of the bombings had been hanged, we wouldn't have to be bothered with the claims to be wrongly convicted. In his famous appalling Vistas speech, which we referred to in each of our recent books, he stated that if he had granted leave to appeal and it had been successful, then that would establish that the police had committed perjury and the expert witnesses had given false or fraudulent evidence, which turned out to be the case. He said that was such an appalling vista, we should not allow these appeals to proceed, and doesn't that indicate what a civilised jurisdiction we are? Australia is the only comparable jurisdiction which has adopted a new right to a second or further appeal in the majority of its jurisdictions, and this will present challenges not found previously in New Zealand, Canada or the UK. It's interesting to note that the Canadian CCRC can order a retrial without overturning the conviction. And I discussed with Ken, I said, this is rather curious, isn't it? Because you have a person who's now actually having a retrial whilst he or she remains convicted of the offence for which they are now being tried. He said, well, it's a little bit peculiar, but it's just the way we do things here. If an Australian CCRC were required to consider whether there is a real possibility that the appeal court would overturn the conviction, this is when the second right to appeal issues now become relevant to the powers and functions of a CCRC. Should they take into account the established law dealing with the prosecutorial duties or the duties of expert witnesses, and by that I mean the established law prior to what I would call the shenanigans that now take place under the new appeal rights, or should they have regard to the new interpretation of the law in these new appeal cases? In Mr. Bromley, the appeal court stated that it was appropriate for the issue of the qualifications and competence of the expert witness used by the prosecution at trial, and this particular prosecution witness has become quite notorious in Australia. I'm sure we all know of him, Dr. Manott, and we've had a wonderful series of programs about the levels of his incompetence and all the rest of it. So would it be appropriate for the issues of the qualification and competence of the expert witness used by the prosecution at trial not to be raised as part of the appeal? it was said in Mr. Bromley's appeal that his defence counsel didn't wish to raise the broader issues about Dr. Manock. And in their appeal judgment, and he did so after having received written instructions from Mr. Bromley to do precisely that. He then withdrew that evidence during the course of the appeal without consultation with his client and without notifying his client that he was going to do so. And in the written appeal judgment issued by the court, they said they thought it was a good idea not to raise the background issues about the expert witness who had been declared by his own Forensic Science Centre 20 years before he resigned to be not qualified to certify cause of death and not competent to give expert evidence in court. He then continued to do so for the next 20 years, and over which time he helped secure over 400 criminal convictions and undertook 10,000 autopsies. So the judges on Mr. Bromley's appeal said it would be a good idea not to raise the issues about his background incompetence. And in fact, on one television programme that we did on Channel 9, the lead pathologist in the UK was so shocked by what he had read, he exclaimed to a national audience in Australia, "This man's a charlatan. He's gone rogue." It's a disgrace. Anyway, decisions of the South Australian Court of Criminal Appeal are said to be binding on subsequent hearings of the appeal court. So if a matter involving the same expert was to come before the CCRC, requesting a referral to the South Australian Court of Criminal Appeal, would they be required to disregard the evidence of that witness's lack of qualifications and competence? Would they be obliged to follow what the Court of Appeal had already done in Mr. Bromley's appeal? Would the CCRC have to abide by the ruling of the Court of Criminal Appeal and disregard what would otherwise be a shocking failure of prosecutorial disclosure? It's one thing for defence counsel to say, "I'm not going to make mention of this," but if there have been matters adverse to the competence and integrity of a Crown witness, the prosecution have a duty to disclose that. The court knows about those issues, and it's not asking the prosecution, "Are you intending to fulfil your duty of disclosure?" In fact, if you look at my website under Dr. Manock, you'll see a letter I sent on the 20th of March 2023 to the DPP and to the Attorney General and to the Premier, saying that he should, when he goes to the High Court on Mr. Bromley's appeal, make full disclosure of the issues that we had raised. We did explain in the letter the extensive failures of the expert which were on record and not in dispute, and you can look at the letter yourself. We did point out that the previous court decisions in Australia had stated that failures to disclose such issues would be an unspeakable outrage or even, I quote, criminal misconduct at the extreme end of official corruption. Similar letters were sent to 3 consecutive Attorneys General who each declined to issue an instruction to the DPP to comply with his duty of disclosure, and the High Court was, in Mr. Bromley's case, subsequently informed by the prosecution that the judges could rely upon the evidence of the impugned expert because his evidence had not been challenged at trial. And the obvious explanation for that was because defence counsel at the time of the trial didn't know about that. So would an Australian CCRC refer such a case back to the courts, and what sort of report would they provide to the court in respect of such a referral? Of course, it might be possible to direct the CCRC to refer cases which it thought represented a substantial miscarriage of justice and open the possibility of a potential conflicts between the CCRC and the Court of Criminal Appeal hearing leave to appeal applications. Alternatively, it might be possible to direct the CCRC, after its investigations were complete, to refer the matter to the CCA as an application for leave to appeal, and this might be a proposal that would come forward by politicians when you're talking about setting up a CCRC. Let it do the investigations, but then let it refer it back to the appeal court and let it then become an application for leave to appeal to be dealt with by the appeal court rather than the grant of leave to appeal by the CCA. So refer the matter to the CCA as an application for leave to appeal as a second to further appeal. This is an option not available in other jurisdictions, the overseas jurisdictions. And whilst that might be politically the most attractive option to neuter the effect of an emerging CCRC, we suggest it would be a disaster from the perspective of justice and the rule of law. Unless we can do something to alter the effect of the Court of Appeal decisions in Mr. Bromley's appeal, the prospect for referrals, I suggest, or successful referrals from a CCRC will in fact be substantially compromised. So I suggest that in addition to looking at the issues of how we actually set up the CCRC, how we deal with its powers, we must look at these emerging interpretations of the law would be substantially against the interests of a successful CCRC. Thank you very much.